Kendry, case number 25-04384-DM. Present in the virtual courtroom, we have both parties along with their respective attorneys. And we are here on the plaintiff's motion to enter the judgment of divorce. We're also here on the plaintiff's motion for payments. Ms. Van Dyken.
Thank you, Honor. I think I can take the motion for payments first. It appears that counsel for the defendant agrees with me in his response to my motion to enter the judgment. Under paragraph 4, it appears that he says he should pay her the fees, the payments, or the child support. He hasn't paid the child support, so he should pay the fees, the payments, and those should be paid in a lump sum to her.
All right. Can we take one issue at a time?
That's fine.
Okay. Mr. Burke?
Yes, thank you, Judge. That's not our position. So it's really a timing play here between payments that were going solely to Ms. McKendry throughout the pendency of this matter, and then the child support, which is supposed to take play once the judgment of divorce is entered. The reality, which is really the first motion that I think, I'm not sure why Ms. Van Dyken doesn't want to address it first, is that we're waiting on plaintiffs to approve a judgment of divorce that we provided over 2 months ago that has.
Okay, I don't want to get in. Let me switch back to Ms. Van Dyken on that. I just wanted to check to see if, in fact, we had an agreement on that, the payments issue, and it doesn't seem like we do.
Under number 4 in their response to the motion to enter judgment, it strictly says defendant is fine with if the court enters either. Defendant has to pay the $19.50 biweekly or the monthly child support. We're asking for the $19.50 biweekly, and they say they're fine with it. So I'd like the court to make him have a lump sum payment. That's your response. I can't change your response. Under paragraph number 4.
I think it's one or the other.
It is.
And I think because we don't have a judgment entered, we need to continue to make the payments, the status quo payments that were agreed to last year, and that's the $19.50 biweekly.
I would agree. I mean, it's one or the other, and it sounds to me like, I mean, we haven't entered the judgment yet, so those payments should have continued.
Judge, may I expand on that?
Okay.
It is a one or the other, and the issue in the payments is that our position is that Ms. McKendry has delayed entry of the judgment of divorce in order to get double the payment amounts, because she should be getting approximately $2,000 in child support. And what has happened is we are essentially agreed since March 17th, since March 27th as to all terms of this judgment of divorce. And that is when these biweekly payments should have stopped and the child support should have began. But because
again, this is math. So, I mean,
you can't have it both ways. You can't not pay the child support and not pay that. You can't pay for avoidance.
If you want to have the child support start as of March, whatever, that's fine with me too. Like I said, it's one or the other.
And that's what we're requesting, is that child support should have been started.
You said you were fine in your response to the $19.50. That's what my client is seeking. Because there is no judgment entered yet. No child support.
And that's the result of plaintiff delaying a judgment.
All right, hold on. I will simply make the child support effective as of March 1st. Okay, next issue, Ms. Van Dyken.
It's the entry of the judgment, Your Honor. Our judgment does comport with the mediation agreement. The superfluous changes that Mr. Burke is asking for with regard to the Ottawa County schedule, that's not the Ottawa County schedule, that's other things that he's asking for. He then also says that my client owes a great deal of money. He, again, says for taxes. Quite frankly, if he owns the business as of that date, he's responsible for the business taxes, not my client. He is. So he's paying those fees, because now the court just ordered that he's supposed to be paying child support. That's his business. Those business taxes are his. He needs to pay those, not my client. Your Honor, my judgment absolutely comports with what was in the mediation agreement. My client is not responsible for transportation of these children.
Things take a dramatic turn as the focus shifts to the judgment itself. Both attorneys argue over whether the proposed document truly reflects the mediation agreement.
He only has daytime visits as of now. he hasn't moved. I don't understand the superfluous language. And I understand that we did agree to go back to Mr. Danema with regard to language differentials, but what they're trying to do is add language to the mediation agreement, not follow it.
All right. Mr. Burke, just let me ask you very plainly, what is in the judgment line by line that does not comply with the mediation agreement?
Sure, Judge. So going into page 2, and this is attached to our response of legal custody. As written, it says that the parties shall consult and attempt to agree before major decisions are made. We're just trying to clarify, consistent with legal custody, that no party shall make such a decision without written approval of the other party.
Which
As
paragraph?
written, it implies. Sorry, Judge.
Which subparagraph is that?
It's under custody, subparagraph A. There's a tract.
Oh, I see it. I'm looking at the proposed judgment. So thank you. I just couldn't find it. I'm sorry. Go ahead.
So under custody, subparagraph A, we're just trying to clarify that decisions must be mutually agreed on, because as written right now, it just says that they have to attempt to agree. And as we know, legal custody, they have to both agree or they have to seek court permission as to legal custody concerns. So that's
all right. Hold on, Ms. Van Dyken, on that issue.
Your Honor, it's superfluous language. They have to agree. It says they must attempt to agree. It's just, again, superfluous language, something to probably churn their bill.
So if the attempt was removed, would you be okay with that? If the word attempt?
Shall consult and agree. I think that would be fine.
Okay. Next.
The next issue would be the drop off, and there is not any agreement as to drop off or pickups. So we included in there that Mr. McKendry would pick the child up at the beginning of parenting time, and that plaintiff would pick up at the end of parenting time. That's a consistent standard provision regarding transportation. Originally, and as shown in the record, is that Mr. McKendry originally was supposed to get Sunday overnights. So
okay, let me just stop you. Is that contained in the mediation agreement?
There's no language concerning pickup or drop off for either party. And what was written in there is pretty much unilaterally making Mr. McKendry do all of it. So again, if there's no provision at all, then that's still an ongoing issue as to transportation. So they're trying to say it's on my client when there's no agreement that he's going to be the one providing. And we're just trying to split it down the middle as to.
Ms. Van Dyken, what's your position on that one?
Not included in the mediation agreement, Your Honor.
And neither is my client picking up either and doing all of the transportation.
Well, it's not included in the mediation agreement, but I haven't heard any reason why the parties should not share in the transportation. That is typically what happens. The parent beginning their parenting time picks up at the beginning and the end, depending on which parent it is who's going to be spending time with the children. What's next?
This is on page 4. There is some provisions regarding no contact with certain households. And we're just trying to clarify that my client who's living in his brother's home can still exercise parenting time there, although no overnights can be there.
Can you point me to the paragraph that you're referring to?
It's the top of page 4, the very first paragraph there.
Is it ordered that until he has stable housing, that one?
Correct.
Okay. And what
I'm not sure, Judge, if you're looking at the one attached to our response that has all the proposals.
I'm looking at the one that was submitted by the plaintiff.
Yeah, our response attached as an exhibit has our specific red lines in it, which are what I'm going through line by line.
He's asking for a sentence about avoidance of doubt. There is clearly no doubt, because if the court looks at page 3 of my judgment, it says he is not to have overnight at his brother's home, and there will be no contact for the children with the defendants.
The tension keeps building as both lawyers spar over a single sentence. Arguments focus on overnight stays, daytime parenting time.
Mother Sandy's home. That's pretty clear. You don't need a sentence that says for the avoidance of doubt.
We're just trying to make sure that the parties are clear in their obligations here. And quite
I
frankly,
think that's extra words that if it wasn't included in the mediation agreement, we don't need it. Or we shouldn't include it.
if there's any, again, it just keeps the door open on whether or not my client can exercise parenting time where he's living during the day. And there's no dispute that he can do this here from what I'm understanding. So if that's on the record from Ms. Van Dyken that my client can do that, then we don't need that in the judgment. If there's
He cannot exercise parenting time at his brother's home.
He cannot exercise overnight parenting time at his brother's home. That is what the mediation agreement says. So this is why this is an actual dispute, because she's saying it's just superfluous language, but now on the record, Ms. Van Dyken saying, no, he can't do it. And the mediation agreement says no overnights. So we're trying to clarify that point to avoid an issue down the road in front of the judge.
If it says, oh, no overnights, it's no overnights, pending modification.
I agree with you, but now we have Ms. Van Dyken saying that he can't exercise parenting time under her interpretation of the mediation agreement in this house.
My judgment is pretty clear and meets with the mediation agreement. Yeah. Okay.
So again, and I'm sorry, but I do not have your redlined, it's not in what I'm looking at. It may be a paper file, but I don't have it. So that's why I'm looking at Ms. Van Dyken's judgment. So it would really help me if you kind of walk me through it.
So
again, what's wrong with that first paragraph on page 4?
we are just trying, so there's a provision that my client is to not exercise overnights because of where he's living. There's no agreement in the mediation agreement or otherwise that he can't exercise his daytime parenting time where he's currently living. So we are trying to clarify that.
All right, it says it's further ordered that until defendant has stable housing, his every other weekend parenting time will be Saturdays and Sundays during the day from 9 to 6. So I'm having a hard time figuring out what's wrong.
My apologies, Judge. Page 3, the paragraph at the bottom of page 3.
Okay.
There we go.
All right. Further ordered that the defendant's overnight parenting time shall not begin until he has stable housing and safe and appropriate. He's not to reside with the children in his brother's home. And there'll be a no contact order for the children with defendant's mother, Sandy's home.
So it says he's just not to have overnights there.
It says he's not to reside with the children in his brother's home. To me,
Yes.
Reside does not mean daytime visits.
And that we would agree with you, Judge. And that's why, based on Ms. Van Dyken's representation, that her client is obviously taking an issue with parenting time occurring in the household during the day. That is why we added for the avoidance of doubt.
I don't think my client's arguing about that because that's what he's been doing. I'm just saying your superfluous language is not necessary because of paragraph 3.
I don't think we need that extra language.
Thank you.
What's next?
The second paragraph on page 4, the parties will work together for any events for the minor children during the week. We just made a very minor, and it's consistent with the transcript actually, should either party wish to take the minor child to any events. It's just a clarifying change in that.
So tell me what it should read from your perspective.
The parties will work together should either party wish to take any minor child to any events during the week.
Ms. Van Dyken, do you have a problem with that?
No, Your Honor, that's fine.
Okay, next.
I would have known about that for Tuesday.
I believe the next thing would be the Ottawa County holiday schedule.
And what paragraph are you referring to now? Again, Ms. Van Dyken's proposed order, because that's all I've got.
Sure, Judge. It's the bottom of page 4. It starts with holiday parenting time. So we are just adding, if the parties are unable to agree, they shall follow the Ottawa County Friend of the Court parenting time procedure, which is incorporated herein by reference and which is as follows. So that's the added language to the bottom of paragraph.
The courtroom dives deeper into holiday details. Christmas breaks, birthdays, and schedule formatting become the focus. Despite lengthy discussion,
4.
And how is that different that from if the parties are unable to agree, they will follow the Ottawa County parenting time schedule below?
That would just be the minor change, and then we go into on the next page the over or the odd years, even years are wrong compared to the Ottawa County friend of the court schedule. So we have in our edited track version, we have it switching around between mother and father, consistent with that schedule. And I believe Ms. Van Dyken said she agrees with that, but I could be mistaken.
Is it substantially different than what she's got?
The even odd years are flipped around, so it doesn't matter.
Okay, all right.
And then it doesn't include anything, the extra language through the Ottawa County regarding Christmas break splitting. It also doesn't include Ottawa County's reference to birthdays.
I see children's birthdays on here. I also see some language about Christmas break splits are intended to grant the parties 1 week, each 1 week with the children.
That's the exact
In my version in our attached, I have that highlighted as red track changes. The party shall share the Christmas break equally, starting on page 6 after the table. That's what we had added in for requested changes.
I just don't see how that's different than what's there. But maybe I'm missing something, but.
Mr. Danema provided us a copy of the Ottawa County parenting time schedule, holiday schedule, and that is exactly what I put into my judgment.
Okay. Do you agree that the odd even needs to be switched, or you're okay with switching it?
I'm okay with switching it.
Okay. Was there anything else about that?
No, I just need to look, Judge, very quickly at the version you're looking at, because mine has the red lines for the Christmas break split and the birthdays not being included in there. But again, if we're in agreement that that is the language from the Ottawa County front of the court, that should be included.
I'm looking at it. It says children's birthdays. It's the last thing in the last item in the table. And then it's got Christmas split break language below that.
The language that we've put in, I see what you're saying now, Judge, my apologies. The language that we put in there matches verbatim with the Ottawa County front of the court schedule. And I can read that if you'd like. And then the version.
How is it materially different? That's what I'm trying to figure out. That's all. I mean, I don't know, Ms. Van Dyken, do you have any?
Again, Your Honor, we could have had this judgment entered when I sent it to him. It's superfluous.
And the birthdays wasn't even on the one that we got from you, Ms. Van.
Okay, all right. This is not helpful.
We asked to add that.
This is not helpful. So, any problem with using his proposed language for the Christmas break?
No, Your Honor, no.
Okay.
But
Okay, I just don't see the difference, but so there's no point in fighting about it. What's next?
Under child support on page 8, consistent with the mediation agreement, we just asked for clarification that the overnights would be calculated at 125 overnights.
Contained in the uniform child support order.
The child support order is the order, not the judgment. So is the attached order correct?
The attached order is correct. That was the only stylistic change that Ms. Van.
Again, a stylistic change and not one that I think has any substance. What's next?
Those are all the requested changes. They were very minimal, Judge.
Okay. Well, the court will enter them with the items that the court has ruled on. Then, Ms. Van Dyken, can you make those minor changes and submit it?
I can, Your Honor.
Okay.
Your Honor, we have one other additional issue. We did a stipulation. We have been requesting the payment of the house proceeds for my client that she was awarded in full from Mr. Worth's trust account. He is not sending those. I would hate to have to file a motion for contempt of another lawyer to do that, but I would ask that Mr. Burke reach out to Mr. Worth and get those proceeds sent to me or my client ASAP, because that's going to impact once this judgment is entered. When she receives those funds, then the timeline starts ticking about car payments and returning the car and those kind of issues. So that's something I'm just seeking assistance from Mr. Burke to get that done.
Okay, Mr. Burke?
Judge, we are not opposing the release of those funds. We're obviously waiting for a judgment of divorce. I don't know if Ms. Van Dyken provided Mr. Worth with a copy of her motion, but my understanding is that he requested a W-9 in order to release the funds, and that hasn't been provided.
And there's no reason
I don't know his, Ms. Van Dyken may finish. I don't know if what the basis of, but that seems to be an issue between plaintiff and her former attorney.
There's no reason for a W-9, Your Honor. These are house proceeds from an IOLTA account.
I'll order that the money be turned over upon entry of the judgment.
Your Honor, I saw my client. She tried to say something. I know this is motion morning. I'd like to at least speak to her to see if there's something that I'm forgetting.
Okay, we can put you, we'll stop the recording and the YouTube.